Chapter 46. Creditors' Bills Against Stockholders. Analysis. Section 896. The Trust Fund Theory. At law, the relation of creditors to the corporation is the ordinary relation of debtor and creditor, and in the absence of statute there is no relation between creditors and stockholders. But in equity, in many cases, judgment creditors are allowed to maintain bills against stockholders in private corporations. The so-called trust fund theory attempts to explain the jurisdiction of equity to enforce the liability of stockholders to the extent of the par value of their stock through a trust imposed on the capital stock of the corporation in favor of its creditors. In the words of Justice Story, the inventor of the doctrine, the capital stock is a pledge or trust fund for the payment of the debts created by the corporation. This view, propounded in 1824, seems to have been little questioned, until the first edition of the work of which the present treatise is a supplement. Subsequent criticisms of the doctrine by the Supreme Court of the United States and by other courts quote with approval the language of this section, and the best considered of the recent cases represent a complete recession from the earlier view. Section 897. Objections to the theory. Aside from the fact that it is impossible to grasp the idea of a trust neither expressly declared, nor raised by the law either as a constructive or resulting trust, it will be found that the theory will not square with the decided cases, nor with the demands of commerce and corporate business. Thus, if the theory were strictly maintained, any creditor of a corporation could maintain a bill to recover assets constituting portions of the capital stock which have been divided among the stockholders or otherwise diverted, but no case has gone to the length of holding that anyone other than a judgment creditor whose legal remedies have been exhausted, or who is prevented by some reason from exhausting his remedies at law, may maintain the bill. And the mere fact of insolvency on the part of the corporation, the right to pursue legal remedies remaining, will not obviate the necessity of exhausting those remedies. This view alone, established by the universal trend of authority, shows that the plaintiff maintains his bill in such cases not upon the ground that he has an equitable right to enforce, but rather on account of the inadequacy of the legal remedy. Other instances where the trust fund theory fails when brought to bear on the decided cases, may readily be found. For example, the prevailing view is that creditors who become such with notice that the stock has been watered, cannot complain as to the overvaluation, but if there were a trust in any proper sense, the creditor's knowledge would be immaterial. If a trust existed in his favor he could enforce it in the absence of lackeys, or bad faith, or some other defense. If the trust fund theory be adopted, other inconvenient results follow. For example, if a corporation does not hold its property upon the same title by which a natural person holds his property, it would result that it could not dispose of its property absolutely except to a bona fide purchaser for value and without notice. Persons, therefore, who had bought goods from a trading company would be liable to have the goods taken from them, if before payment of the price they learned that creditors had claims. And a corporation could not, under any circumstances, prefer a creditor in good faith or give him security, say, for an antecedent indebtedness. Yet some courts which profess to hold to the trust fund theory allow the same right to corporations to make preferences, that natural persons have. Upon considerations, such as these just enumerated, many courts have been substituting in place of the trust fund theory as a basis for equitable jurisdiction, the fraud or misrepresentation theory. Section 898. The fraud or misrepresentation theory. While this theory received more or less support from the earlier cases, it is even suggested in the case of Wood v. Dummer, but the court was struggling there to support a bill stating acts constituting fraud, yet not charging fraud. The opinion which gave definite shape to the theory is that of Mr. Justice Mitchell in the case of Hosps v. Northwestern Manufacturing Company. According to this view, the stockholder who pays less than par value for his stock which is issued to him as fully paid, or who pays for his stock in overvalued property, perpetrates a fraud upon those who subsequently deal with the corporation. While this suggestion avoids many of the difficulties raised by the older theory, it raises others, as, for example, why, if in fact the shareholder makes a misrepresentation which causes damage to the creditor, should not an action at law lie as well as a bill in equity? But no such action has ever been successfully maintained. Again, Suppose that the creditor's claim arises not from any representation. Suppose, for example, that the demand was originally for personal injuries sustained by the plaintiff by reason of the corporation's negligence. It is plain that the theory breaks down, and it is also apparent that this view will not explain the right of a judgment creditor to call in unpaid subscriptions. Professedly, it applies only in cases where arrangements have been made between the corporation and the stockholders, relieving the stockholders from the ordinary effects of a contract of subscription. Again, why is the transferee of stock ever liable on this theory, especially a transferee who takes the stock after the plaintiff became a creditor? And lastly, in the matter of parties, why, under the fraud theory, is it necessary to make the corporation a defendant to the bill? Yet it is perfectly settled that the corporation is a necessary party to the bill, and that the equitable remedy is enforced through the corporation. Section 899. Suggested modification of the fraud theory. The last objection might, it is true, be avoided by treating the representations as having been made by the corporation for its stockholders. In this view, the liability is contractual, so that, as was held in Curran v. Arkansas, the repeal of the liability of the stockholders would be a law impairing the obligation of the contract between the creditor and the corporation. If the liability of the stockholder rested wholly in tort, this result could not follow. But it must be confessed that, even with this modification, the representation theory is not wholly consistent with the decisions in the particulars pointed out in the last section. Section 900. A theory of liability based on analogy to partnership. A theory to support the liability of stockholders in equity has been propounded by some authorities as follows. At common law, the liability of incorporators is that of partners. The Charter enables them by statute to escape this liability by paying for the stock of the company in money or money's worth. Entire immunity from individual liability is not invariably incidental to the grant of a charter or articles of corporate existence. If the legal conditions are complied with by the organizers of the corporation, the immunity follows as a matter of law, but if they are not, an individual liability of the shareholders arises, imposed by the same power which granted the right of corporate existence and whereby creditors may make their claims good. The difficulty with this view is that it establishes too much. It might be questioned whether there is any common law liability imposed on corporators. Aside from this, however, the doctrine leads to the inevitable conclusion that the liability should be enforced at law, not in equity. The stockholder, on this view, would plead in confession and avoidance the due payment of his subscription, amounting to a discharge of his liability. Section 901. Public policy theory. It has been said that the liability of stockholders to the creditors of the corporation is based on no consistent theory, but is simply a more or less systematic judicial recognition of a demand of the commercial world. That demand is, in substance, that the liability of a stockholder shall be unlimited up to the par value of his shares, and that he shall not be entitled to the benefit of any legal principle which would normally entitle him to an advantage against corporate creditors. This is not a legal theory. It is a commercial condition struggling for recognition in the courts. And Mr. Justice Temple, in a California case, says, the corporation is supposed to have sought credit based upon its supposed capital. Public policy requires that the fact whether a particular creditor did trust the corporation on that basis should not be inquired into. Adopting the same view of the origin of the liability, a recent writer declares that the jurisdiction of courts of equity in such suits is based on no principle whatever and should be abandoned. Section 902. 6 distinct classes of creditors' bills against stockholders. The truth seems to be that all of the cases cannot be explained on any single principle, and the reason they cannot be so explained is, it is suggested, because several distinct things have usually been treated under one title. In fact, there would seem to be several distinct classes of cases where stockholders are held liable in equity at the suit of creditors, governable by different principles. The cases may be classified thus. 1. The stockholder may have subscribed for stock to be paid for in money, and, by the terms of his subscription, no call has to be made to render him liable, or the call has already been made. 2. Under the same contract of subscription, a call has to be made before the stockholder will be liable to pay. 3. The corporation has agreed that the stock issued to the stockholder for money, at less than par, shall be considered as fully paid. 4. The corporation has issued its stock as fully paid for property conveyed to it in lieu of money, a. such property being grossly overvalued by the corporation, or b. being materially overvalued, but the corporation acting in good faith and in the exercise of its best judgment, or c. the property being materially overvalued, and the corporation not acting in good faith, or d. the difference between the valuation assigned and the true value being immaterial. This class of cases sometimes involves statutory and constitutional provisions against watered stock, giving rise to further distinctions. 5. A fifth class of cases, often treated under the trust fund doctrine, to the obscuration of the subject, is that where the corporation has conveyed the assets representing its capital to stockholders or others in fraud of creditors. 6. Lastly, in certain cases, the corporation having been dissolved, the directors or trustees in liquidation have had the duties of trustees imposed on them by statute. The case of Wood v. Dummer on which the trust fund doctrine was based was really a case of this kind. Section 903. Cases of the first class, money subscription, no call required. In the first class of cases, under modern systems of procedure, the debt from the stockholder to the corporation, being a legal debt, is garnishable. But though statutes have adopted equitable remedies in ordinary legal proceedings, it is usually held that the jurisdiction of equity is not, by reason of such extension of equitable doctrines and practice to actions at law, abridged or destroyed. Generally, it is held that where statutes permit garnishments in actions at law, the remedy by judgment creditor's bill is unaffected. At least one court, however, adopts the view that, in cases of this class, garnishment is the sole remedy. In those states which allow a judgment creditor's bill to be maintained for the purpose of reaching choses in action of the debtor, the bills of the first class are plainly based upon the ground that the debt is a chose in action which, from its nature, was not the subject of execution at common law. In other words, the jurisdiction, in this class of cases, is based on the inadequacy of legal remedies. Section 904. Cases of the second class, money subscription, call necessary, where the formality of a call is necessary to create a legal obligation on the stockholder, the court of equity will entertain the bill upon the ground that the debt of the stockholder is an equitable asset of the corporation, that the directors have omitted to perform a formality which they should have performed, and equity, regarding that as done which should have been done, will treat the call as having been made, and proceed as in the first class of cases, or, though there would seem to be theoretical difficulties in the practice, will order a call to be made by its receiver, and the fund to be collected by him in actions at law. The proceeding by a judgment creditor to collect unpaid subscriptions has been called an equitable garnishment. Section 905. Cases of the third class, money subscription, underpaid stock issued as fully paid. In this class of cases we approach a new principle. The stockholder has paid less than par for the stock, but the corporation has agreed that the stock shall be considered as fully paid. The release is binding as between the corporation and the stockholder, and the creditor also is bound by the agreement until it is set aside. However, he may have it set aside as in effect a fraud upon him. Section 906. Cases of the fourth class, subscription paid in overvalued property. A. Where the property for which stock has been issued is taken by the corporation at a gross overvaluation, or where the stock is issued as a bonus without any consideration. The case is like the third class of cases just mentioned. The fraud may be inferred as a matter of law, and hence need not be alleged. The relief is somewhat peculiar, for equity does not demand the restoration of the property conveyed, but charges the stockholder with the difference between the value of the property conveyed and the par value of the stock. B, and C. In these cases, the bill should not only show the material overvaluation, but should affirmatively charge fraud. The inference of fraud that might arise from the proofs that the property was overvalued, would, in any event, be rebuttable by proof that the officers of the corporation acted in good faith and in the exercise of their best judgment, though it must be admitted that there are cases which disregard these elements. In determining the question whether or not the officers of the corporation did act in good faith, the character of the property is, of course, unimportant element. If the stock was issued to a stockholder in return for an untried patent or an undeveloped mining location, for example, the directors would have greater discretion in the matter of fixing values than if the stock were issued in return for the conveyance to the corporation of improved real estate or of an established business. D. If the difference in value is inconsiderable, equity will not interfere with the arrangement into which the corporation and the stockholder have entered. Authority may be found denying relief under this fourth class, which is the most frequent in practice, proceeding upon the ground that the stock is not property until issued and has no value, and therefore, in the absence of statute, it may be given away, without giving cause to the creditors to complain. But this view overlooks a fundamental proposition underscore, namely, that in addition to the charter, a corporation is made up of a series of contracts of subscription. Of course, in all cases, the question is as to the value as it appeared to the directors when the property was taken. Section 907. Cases of the fifth class. Conveyance of corporate assets in fraud of creditors. This is the ordinary case of fraudulent conveyances of property by a failing debtor, and the bill rests upon the two elements of fraud and inadequacy of legal remedies. Section 908. Cases of the sixth class. Corporation dissolved, directors liquidating as statutory trustees. In this class of cases, where proceedings are brought by creditors for the purpose of winding up a corporation, or administering the estate of a dissolved corporation, we approach the case of a real trust. Upon dissolution the corporation ceases to exist, at common law, for all purposes, so that its debts were extinguished. Equity, however, required the trustees in liquidation to pay the claims of creditors before paying those of the stockholders, the nominal beneficiaries. It will be noted that in the ordinary administration proceeding the jurisdiction of the court depends upon a trust existing in favor of the stockholders. But equity having obtained control of the fund administers it upon equitable principles. Even in this case, therefore, in the absence of statute, there is no trust in favor of creditors, though statutes, at the present day, very often give creditors the right to file bills for a winding up of the affairs of the corporation. Section 909. Questions of pleading and practice in connection with such bills. The allegations of the bill, questions of parties and other matters of practice arising in connection with bills by creditors may be determined by considering under which class the bill should be placed. Though there has been some confusion as to whether all of the stockholders are necessary parties to the bill or whether it is sufficient to proceed against a single stockholder, it would seem plain that only in the last class of cases is it necessary to make all the stockholders parties. Other stockholders may, if the defendant thinks their presence necessary for his protection, be brought in by a cross bill, but it is not indispensable that such cross bill be filed. The bill should be filed for the benefit of all creditors who desire to become parties, but even though not expressly filed for the benefit of such other creditors, any creditor may nevertheless establish his claim in the suit. If the action is brought to set aside fraudulent conveyances made to the stockholders, only those participating in the fraud or benefiting thereby should be joined. As the equitable remedy is enforced through the corporation, it is, of course, necessary, where the case is under any of the first 5 classes, to make the corporation a defendant. The plaintiff should allege a judgment and the return of execution unsatisfied in all cases where it is possible to pursue such, in those cases which are equitable garnishments, for the sole purpose of showing the exhaustion of legal remedies. In the cases based on fraud, to show the damage as well as the inadequacy of the legal relief. A judgment rendered in a sister state is not a sufficient exhaustion of legal remedies, upon which to base a bill in equity, though in the Glenn cases, before referred to, the decree of the Court of Equity in Virginia making the call was held sufficient to warrant the receiver in bringing actions at law in other jurisdictions. The judgment against the corporation is conclusive against the stockholder, and the merits of the creditor's original claim cannot be relitigated. If the bill shows that the creditor had notice of the fraudulent arrangements between the stockholders and the corporation, as stated under the discussion of cases of the fourth class supra, it is demurrable, but on principle, it would seem that, in cases under the first and second classes the question of notice should be immaterial, and no cases have been noted where knowledge or notice has affected the creditor's right to file a bill to collect unpaid subscriptions. If, for example, the Court of Equity orders a call, the fund produced as a result thereof should inure equally to the benefit of all creditors, and so of property which has been fraudulently conveyed and is recovered, it should inure to the benefit of future as well as existing creditors. So as regards the stockholders who are to be made parties defendant in such bills, if the stock is unpaid and is not represented to be paid up, any transferee of the stock is liable, and, if the original stockholder has transferred the stock while the corporation is solvent and without any intent to escape liability, he is released from liability. But where the equitable jurisdiction is based on fraud, it is apparent that the participants in the fraud cannot be released by any transfer of their stock, and on the other hand, that the transferee will not be liable if he be a bona fide purchaser of the stock for value and without notice. In truth, there is a theoretical difficulty in holding any transferee of the stock on the ground of fraud. Of course, when the court, under whatever head of equity, acquires jurisdiction of the parties and of the subject matter, it will apply equitable principles to the administration of the fund that comes under its control. Accordingly, it will not permit a stockholder to plead, as a set-off against the creditor's claim, a debt owing by the corporation to the stockholder. But it is not necessary to invoke the trust fund theory to support this doctrine, which is simply the application of the principles of chancery practice to a matter already in the court's jurisdiction. The plea of the statute of limitations will also be governed by the nature of the bill. If the assets were legal, an unpaid subscription, after a call was made, the creditor should be barred when the corporation is barred. Where a call is necessary, no statute should run until the call is made, or what is the same thing, until equity disregards the formality of the call and makes the proper order. In cases of fraudulent conveyances, the statute should run against the creditor from the time he has notice. In cases of arrangements whereby the stockholder has been released by the corporation, binding the corporation though voidable at the instance of creditors, the right of action would seem not to arise until the creditor exhausts his legal remedies. The decree in all cases will be framed on equitable principles. The court may or may not require the whole balance to be paid, according as it is necessary or not, and all creditors who choose to come in and prove their debts must be protected by the decree. Section 910. Statutory liability of stockholders in equity. Statutes imposing an individual liability upon shareholders in a corporation are usually held, on familiar principles, not to oust the equitable jurisdiction, unless the statutes expressly require such interpretation. Some of these statutes impose a liability enforceable in courts of law. But where the statute provides in general terms for a proportionate liability on the part of stockholders for the debts of the corporation, it is usually held that the remedy for enforcement lies with the court of equity. In such cases it is plain that the machinery of a court of law is unsuited to determine the proportion. It is necessary to have the corporation and all the stockholders parties to the suit, in order to ascertain what the amount of the deficiency is and how much has to be contributed by each stockholder. Of course, if the proportionate liability is unlimited by the par value of the stock, no such necessity of a resort to equity exists. The bill in equity to enforce such statutory liability should be framed so as to enable all creditors who desire to do so to come in, and by sharing in the expenses of the suit, to participate in the fund. The chief difference between the equitable liability and the statutory liability in equity is, that in the former the shareholder's debt is sought to be collected, in the latter, the corporation's debt for which he is made liable by the statute. It therefore happens that the judgment against the corporation, which is always conclusive against the stockholders in the equi-table suit, may not be conclusive on the merits of the claim in the statutory suit.